All right, good morning, folks. This is the Colorado Oil and Gas Conservation Commission. This is our weekly meeting. It is June 2nd. Welcome everyone to our meeting via Zoom, which we are continuing to do. Hopeful to get into in-person meetings at some point, but right now we'll continue to do this remotely. I see folks are starting to flow into our meeting at 20 plus attendees, 33 participants. We will start with a roll call. Hearings Manager Larson.
Thank you, Mr. Chair. Commissioner Bogue.
Here.
Commissioner Gonzalez.
Here.
Commissioner Hackett.
Here.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 7 out of 7 commissioners present.
Great. Welcome, everybody. Good to see all your faces. Hope everybody had a good Memorial Day weekend. We have an agenda before us. We will start with public comment. I think we have a short report from the Executive Director's Office. We then have commissioner comments, and then we then move into an executive session followed by a lunch break. And then we will take up a matter involving KP Kaufman Company, an enforcement matter. So with that, I would look to Hearings Manager Larson and Hearings Manager Amaro to help with the public comment. I believe we have approximately 7 or so folks that have signed up. And I believe that Marie Venner is signed up first. As is always the case, we have 3 minutes per public comment, and we ask that everyone be respectful. And we look forward to hearing from everybody this morning.
Good morning, commissioners.
Mr. Chair, we will get Ms. Venner in. I believe she's in, and just give us a moment to get our timer going, and we will begin.
Good morning, commissioners. In recent weeks, I've heard some confusion from those in the executive branch about whether the law applies to you in your work. Of course, you and the general public follow regulations. However, you are not off the hook when it comes to the law and signed legislation directly. Cumulative impacts of oil and gas development were dealt with directly in SB 181. The cumulative impacts are to be assessed. Commissioner Robbins has asked the driller to project his cumulative impacts. That isn't doing it. The driller has little or no interest. The private sector is out of control. As we saw in the New York Times this morning, we read how drillers are passing leaking and declining wells, just as coal mining enterprises have done, to other entities less capable of cleaning up. Just asking and hoping for these extractive enterprises to do something in the public interest is counter to their nature of raise profit and get out. Dramatic pollution reduction is required by many laws now. That some in the executive branch would rather render them toothless and commissioners unaccountable does not make it so. These pieces of legislation were passed after much debate and compromise, and they have strong mandates. Attorneys have told us that these are some of the strongest state laws in the country, and it is possible to be sued for non-compliance. Beyond the legal dimension, there are moral and ethical obligations you have to Coloradans who are counting on you to protect public health and the environment. This should not be recast into thinking of yourselves as permitting and allowing industry and pollution and soaking up too much of your time there. You are here to protect the wider people of Colorado. At this point, in addition to breathing benzene and VOCs and having water polluted in our arid environment, Coloradans are super exposed to public sector payouts and coverage of privatized resources, extraction, and profits. We've already seen executive bailouts of oil and gas companies from COVID funds while they lay off staff in this declining and unreliable industry. More money for the 1%. Now it is your job to make sure that well cleanup and capping is paid for by these extractors, not by the public in general funds. Thank you.
Thank you, Ms. Benner. believe we now have Renee Miller-Chacon.
Yes, Mr. Chair. We are looking for Ms. Chacon. She's not in the meeting at the moment. And we've gone through our list and we're not locating the rest of our attendees. Tess Dougherty is also speaking. She is up next, but I'm not seeing Ms. Dougherty in the meeting. We have Steve Douglas and Christy Douglas. Christy and Steve Douglas have just joined, so we can move them into the meeting. So one
I believe
moment.
Ms. Dougherty also has joined.
Wonderful. Okay, so let's do this. We will get Ms. Dougherty in, and then we'll move on to Steve and Christy Douglas. So one moment.
Hi there, good morning. My name is Tess Dougherty and I'm just here today. I appreciate y'all holding this space for us to give public comment. And I just wanted to, reiterate some of the concerns that a lot of people have regarding all of the environmental racism that is taking place in Colorado. The Elyria Swansea neighborhood and Commerce City, Globeville, they are experiencing health impacts and life expectancy impacts that we cannot underestimate how grave and serious they are. And I'm just concerned with it's not enough to just not do anything, or to just try to remain neutral. There's no neutral in these situations. And so we need you guys to take a firm stand against fossil fuel industry that is polluting and harming and has been and has really gone unbridled for the last 150 years and has done more harm to our air and soil and water and the very earth we live on and that sustains our life in 150 years. And now we're facing the problems that we're facing, and we can't wait around and see what happens. It has to happen now. It's like the mothers that I've heard come on here and come on other meetings talk about the bloody noses and the asthma. That's by no coincidence. That is from the pollution. And I'm concerned that Suncor, and I know you guys don't regulate Suncor, but some of the contracts that you are approving are going to be run through Suncor and the pipeline company that they work with. And so I'm concerned that, they're only putting in $1 million of their money a year to air monitor, yet they came out with I think it was over $600 million in first quarter profits of this year. So it's we can't trust the industry, guys. We can't, because we know that even when they say they're doing something, it's still not enough, and it's still not the most that they could do. And so I just would just implore you guys to please take a stronger stance, because it's for everybody. It's for the people in these surrounding neighborhoods, but it's for everybody. On the Suncor call, they had a map of how far out they had wind pattern maps of how far out this pollution reaches, and it's everybody. There's particulate matter that's found on the most remote mountaintops in the world now, and so it's everywhere. We're all breathing this. And so I just would really implore you guys to take a much stronger stance in the direction of justice and sustainability. Thank you.
Thank you, Ms. Dougherty.
So next up, Mr. Chair, we will be bringing in Christy and Steve Douglas. Give us one moment.
Thank you. Hi, this is, good morning, Chair and Commissioners. This is Steve Douglas, and I just wanted to let you know that the comments that were made after the public comments were finalized time that public comments were taken, that didn't sink in very well at all. Mr. Roberts, after, everyone was concluded, you decided to shame us all that made public comments by saying that the commission has done a great job. Well, I disagree with that wholeheartedly. You have all let us down. You have actually increased drilling in all disproportionate communities of color, and you put everyone's health, safety, and welfare at risk with failure to protect all citizens. So after today's public comments are final, please don't shame us again, because I was not very happy at all. And a lot of us felt the same way. And that's very disrespectful. You guys carry on with your business, because what I've seen since you guys taking these seats, you only care about what the industry needs. So I want you to let that sink in and let you process that, because it's very upsetting. And the fact that I make sure I take my breaks or lunches so I can make public comments, and I really want to make public comments that could really get you guys to think about when those permits come before you, put some thought into it. I understand about, you've said it several times, you guys were not supposed to pause or put any kind of a stoppage of permits. But it's just common sense. You should just, you in those positions of power, you could have said, you know what, we're going to take a time out here so we can get things right. Whether it's a month or 3 months. No one's asked you to take a year out. No one's asked you to take 2 years out, but you did not put any pause in this. It's like business as usual. And I sat on city council for 8 years. And if I let people make public comments that got underneath my skin, I wouldn't have served 1 month. We have people who make public comments, and we have to hear from them. Those people that we represent, and we cannot shame them after they have told us how they felt. That is for you to take that and do something with it, not do something against us. So I want you to understand, when people make public comments, please take what they are saying and put some thought behind it. Thank you.
Thank you, Mr. Douglas. We have Christy Douglas up next. Mr. Douglas, is Christy Douglas going to be using the same Zoom account that you're on?
Yes, ma'am.
All right.
Yes, am I unmuted?
Yes, you are.
Good morning, commissioners. Thank you so much again for holding public comment every week. Sorry that there aren't that many people to speak this morning. Actually, you're probably relieved that there aren't. I think that the Memorial Day holiday probably had an impact on people coming out. I want to echo on everything that everyone else has said. And I'm just going to keep coming out every week, no matter how tired you get of me coming and speaking. This morning, all I want to say is that I understand that we're now focusing on regulating rather than fostering, as you were assigned to do in the past. But from what I can see, you're not really regulating in a way that abides by the law that was set in place by SB 181. The 19 stands for the year 2019. It is now the year 2021. And all I keep seeing, because we travel through the neighborhood a lot, is that you're still drilling. And no matter what the regulations are, you're still drilling. And what we can't see is what impacts us, what's underneath the ground, what's in the air, because what's coming off of these new drilling sites can't see. So I just want you to start thinking about regulating in a way that really abides by the law, that protects the health and safety and welfare of the citizens that you serve. Thank you.
Thank you, Ms. Douglas. Mr. Chair, we will go back and see if we can locate Ms. Chacon. Last I looked, we could not find her, but give us one moment. Mr. Chair, I'm not able to locate Ms. Chacon, nor am I able to locate our last commenter, Mr. Ian Thomas Tafoya. So again,
I'm not able to find either as well. We do have a couple of call-in listeners. If either Ms. Chacon or Mr. Tafoya is a call-in, if they could raise their hand and we could identify them. But we're not seeing that happen as well. So with that, I think what we'll do is we'll go ahead and move through our agenda, hear from the EDO's office and commissioner comments. And before we go into executive session, we'll ask one last time to see if our commenters are available. So with that, I believe that Commissioner Bogue has a short report from the executive director's office.
Thank you, Chair Robbins. I have a few quick updates on behalf of DNR Director Gibbs for the commissioners and for the public today. DNR's budget for the fiscal year 21-22 has crossed the finish line. On May 17th, the governor signed the long bill, which finalizes the state's budget that will take effect on July 1st. And our budget package includes a few highlights, including significant ongoing support for wildfire mitigation and forest restoration efforts, funding for post-wildfire watershed restoration grants that protect stream channels and riparian areas susceptible to flood hazards and sediment erosion after wildfire, and staff and operating resources for Fisher's Peak State Park, which is Colorado's newest state park. The legislature is also currently considering bills associated with the Colorado Recovery Plan to provide additional state stimulus funding for additional wildfire mitigation efforts, watershed restoration, parks and wildlife, search and rescue, and continued implementation of the water plan, including support for projects from the 9 basin roundtables to help achieve the critical goals of the water plan. So DNR continues to work closely with the governor's office and with the legislature in advance of the arrival of potential federal stimulus funding from the American Recovery Plan, and expects to receive additional guidance in the coming weeks on how that funding may be directed. So the state's legislative session will wrap up either this week, but more likely next week. And so next month, I can provide a more detailed update on the important bills that passed and were signed by the governor this session. So that's all I have today. Thanks.
Great, thanks for that report. Always good to hear how those things have come together and finished up. With that, would suggest to Ms. Hearings Officer Larson to keep looking. And while she's doing that, we have an opportunity for general commissioner comments amongst ourselves before we move into our executive session. Do commissioners have comments? Commissioner McGowan.
Thank you, Mr. Chair. And I don't know if this is for Commissioner Bogue or someone else, but I'm wondering if at one of our upcoming meetings, we could have a little update about what's going on at the federal level. I think there are a couple bills that have some funding in them for plugging and abandoning wells. And I don't know if, I'm hoping our legislative team is tracking that, and I would love just a little update if that's possible on what's happening there and what we think is going to happen.
Yeah, Chair, if I may, thanks. That's a great point. And I'm thinking that I will work with Director Murphy to figure out which of those federal bills we can really highlight, along with potential stimulus funds that may be coming through and may be able to be spent in this sector. So we'll connect on that.
Excellent. Great point, Commissioner McGowan. Thank you for that. Other commissioners with comments? Commissioner Messner?
Thank you, Mr. Chair. I think we've received some feedback from some of our public commenters that perhaps for some of them, as far as the information that they're trying to convey, that the 3-minute time frame may be a challenge. I think it's important to understand that the 3 minutes is associated primarily with the fact that we set up public comment first thing on our Wednesday morning meetings in order to create a time certain for the public, so that if they do need to take time away from work to provide comment to us, that they understand when that public comment period will be. And in order to continue to have a agenda after public comment, we need to create a time certain and therefore sometimes limit the amount of public comment time that's available to each public commenter to 3 minutes to stay within our agenda. I do think that there may be opportunities to have a longer public comment period to give people 5 minutes or 6 minutes on our Wednesday evening meetings, as we typically don't have a significant amount of additional work associated with our Wednesday evening meetings. And so I'll just throw it out there as an idea, and understanding that those are only once a month, but that may still create a venue for folks that feel constrained by the 3 minutes. Understanding as well that people always have the ability to provide written comments to us as lengthy as they would like. But I didn't know what other folks thought about that.
Thank you, Commissioner Messner. I think that's something that we can give a try. I also am of the opinion that if you are trying to make a statement to us, that generally speaking, you should be able to get that statement, the theme of that statement, within 3 minutes. I also believe that written comment is very helpful to commissioners because we can read it and spend time with it and actually reach back out to the person that's providing the public comment. I also believe that this commission is doing an enormously good job with regard to providing public comment opportunities to our stakeholders. And I think we're hearing from a select group of folks a lot. And so I think we're doing a good job, but I'm open to the Wednesday evening. I believe we do that once a month. And the next one is June 16th. And so maybe we could try that on for size and see how that works out. Other comments from fellow commissioners on that point?
I'm very open to giving additional time. Sorry, Mr. Chair.
Yeah, no problem.
I'm very open to giving additional time on those Wednesday evenings because that seems to be the bulk of our agenda on those nights.
Mr. Chair, I concur as well.
Same here, Chair.
Okay, let's give it a shot on June 16th for our public commenters. We realize you'll likely have 5 minutes to speak to us. We look forward to hearing from you. Looking to see if anybody else has comments for the general good before we move into executive session. Okay, seeing no further comments, AAG Davenport, would you like to work us into the next steps for executive session?
Thank you, Mr. Chair. Commissioners, we do need a vote to enter executive session, and I'll state the purposes of that executive session before that vote. Pursuant to the Open Meetings Law, the Commission is entitled to enter into executive session at this meeting for the purpose of receiving legal advice pursuant to Colorado Revised Statute Section 24.6, 402, 3A, Roman 2. The topics were identified for this executive session were identified on the agenda today. They are to receive legal advice and analysis regarding COGCC enforcement and contested adjudicatory hearing processes, and regarding COGCC staff's motions for commission hearings in docket numbers 2011-00261, that's an enforcement matter for KP Kaufman Company, Inc., and 2012-00279, also an enforcement matter, but for Alta Mesa Services, LP. Mr. Chair, I invite you to encourage a motion to enter into executive session for the matters and purposes I just named.
So encouraged, commissioners.
So moved.
Second.
Okay, we have a motion and a second to go into executive session pursuant to the reasons as indicated by AAG Davenport. All those in favor indicate by saying aye.
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 Any opposed? All right, we will go into executive session. I believe we had this teed up for approximately 2 hours. We will leave this Zoom and then return to this Zoom when we're done with executive session. Folks are encouraged to stick around, and when we get back, we'll get back, but it's probably going to be about 11:30-ish when we would return to this meeting for the continuance of our open session. So with that, thank everyone for participating with us this morning, and commissioners, we will see you in executive session. Okay, folks, good afternoon. It is 1 o'clock on June 2nd. The commission will reconvene. We will start by recognizing Assistant Attorney General Kyle Davenport to initiate the taking us back out of executive session.
Thank you, Mr. Chair. Commissioners, we're returning from executive session. During executive session, the commission received legal advice on the matters that were identified on the agenda for today as commission enforcement and contested adjudicatory hearing processes, and COGCC staff's motion for commission hearings in docket numbers 2011-00261 and 2012-00279. No decisions were made in this executive session and no votes were taken. Mr. Chair, I invite you to encourage a motion to exit executive session.
Great, thank you, AAG Davenport. We're looking for a motion to exit executive session.
So move to exit executive session.
Second.
We have a motion and a second. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Very good. We are out of executive session. Hearings Manager Larson, would turn to you for teeing up the next agenda item for us this afternoon.
Yes, thank you, Mr. Chair. Next on your agenda is docket number 2011-00261, KPK Kaufman, Inc. It is an enforcement matter. Staff filed an expedited motion for a commission hearing requesting that the enforcement matter be brought before you for hearing and removed from the hearing officer. The hearing officer issued a recommended order, or excuse me, an interim decision on that matter, granting staff's motion. So before you is consideration of staff's motion and the hearing officer's interim decision.
Great, thank you, Hearings Manager Larson. With that, I'll start and I'll just get right to where I am as one commissioner, and then we can look to other commissioners and sort of see what people are thinking. First, I believe that we can take this matter up on the motions and that there is not a need, at least on my part, to have further argument or Q&A with either staff or KPK's counsel. I believe we are asked to answer two questions. The first question is, can a party request the commission to convene a hearing on an enforcement matter by a motion to the hearings officer? And that's what has happened here. Staff has suggested that, and KPK has filed a response and staff has filed a reply. And I think we've all read all of that. And then second question is, should the commission remove the KPK enforcement matter to a hearing before the commission? And in my opinion, the answer to both questions is yes. I agree with the recommended findings in the recommended order relevant to the allegations are serious, the preservation of the party's resources, the capacity of the commission to hear the docket versus the limited availability of the hearing officer, and finally an enforceable order within 30 days of conclusion of the hearing is likely to all occur. For all of those reasons, I believe that we should move this matter to a hearing before the commission. And finally, I would note that as a full-time 5-member professional commission, I think it's part of our job that we should be doing more hearings before the commission as opposed to the previous modus operandi of this commission when it was a volunteer board, which was a heavy reliance on hearings officers. AG Davenport sort of suggested that's kind of like the federal magistrate system where magistrates provide proposals and then the court looks into it. I think that we've got the capacity to be able to do that work on our own, and I would like to visit with staff on ways to ensure that the commission can be aware of docket and make determinations of which matters should come before the commission. But with regard to the matter at hand, one, I agree that either party can ask the commission to take an enforcement matter up. Two, I agree with the hearing officer recommended order that we should indeed hear the KPK case. Three, though, I do not agree that we should hear the case on June 23rd to June 30th. Rather, I would entertain a motion that would direct, or I would make a motion that would direct the hearing officer to do four things. One, discuss with the parties how long this hearing is actually going to take. I understand from looking at the pleadings that it was initially thought the 23rd to the 30th. That seems like an extraordinary long period of time for matters that, perhaps there could be stipulated facts. Once the hearing officer determines the amount of time, I would ask the hearing officer to check in with the commissioners on our available dates. I would like to see this before us before the end of July. And I know we've all got packed summers, and so we need to find times that work for us. And then I would direct the hearing officer to schedule the trial so that we could have that trial. And then finally, I personally would like to see the hearing officer continue to handle all pre-hearing matters, pre-hearing conferences and and that sort of thing. I think the hearing officer knows how to do that. I'm not suggesting that in the future we may not want to have one of us assigned to do that, but in this case, I would direct the hearing officer just to continue with the pre-hearing stuff. So that's where I am, and I have no idea where the rest of my commissioners are, but I wanted to sort of lay out my perspective on all this. And so I now would look to my fellow commissioners if you have thoughts, questions, etc. We can move into next steps. Commissioner Gonzalez.
Thank you, Chair. So I'm with you on most of the points asserted. I do believe that we have the authority to do so. I believe that there's appropriate circumstances when this commission would take on an enforcement hearing outside of the hearing office. For me, when I'm considering this particular matter on the facts presented on the filings that have been published, that we've been presented with, and that we've all read, I still would like to hear just a little bit more detail on the urgency associated with the matters coming before us as a as the commission, as opposed to the timing and the potential kind of offsetting delays with it going before the hearing office. So Director Murphy, if you'd be so kind as to share with me a little bit about the urgency for why the commission should be hearing this particular matter and taking it off the hearing office's agenda.
Apologies for a slow response. Thank you for the question, Commissioner. In my estimation, these are important matters to move forward, and as we have been holding positions open, we have held open to hearing officer positions, and we're seeing an influx of OGDP applications. So to me, there's like an internal resource question about hearing officer availability and accessibility. That's an important component. And the other component for me is wanting to make sure that these enforcement matters move swiftly. I think that with the amount of time that our staff has been dedicating towards implementing 181, we haven't had as much capacity for enforcement, and so it's really time to start moving enforcement matters along. And these matters are important to us, and we've been moving quickly on them. I don't know if AAG Stafford would like to chime in, or I guess, Commissioner, I should ask if you want to hear from our AAG on this as well.
I'm fine to hear from AAG Stafford. The meat of my question, what I'm really getting at, just to add a little clarification there, is specific to the NOAVs and the allegations associated with those NOAVs, the urgency of addressing these enforcement actions with the timeline presented to the commission versus, as alleged, the timeline presented to the commission would be shorter than that presented to the hearing office. And I'm wondering, do the NOAVs dictate that urgency? And if so, why? So I think that's more the question I was trying to ask. If I said that unclearly the first time, I apologize.
Director Murphy or AAG Stafford?
Thank you, Chair. Based on staff's filings here, excuse me, we believe the content of the allegations at issue here do strongly suggest that these matters are important to have the commission hear in an expedited time frame. These are serious, they necessitate immediate compliance with the rules, and staff is very concerned that if we do not receive a final agency action on these particular matters, that there could be issues, significant impacts to public health, safety, welfare, the environment, and wildlife resources. So that is part of our push to have the commission hear this in an expedited manner, getting final agency action so that we have an enforceable order in a more timely manner.
So I guess, is it fair, I was thinking back to the filings and I don't recall if I had written it down, and I'm looking through my notes now to see if I can find that. But is it fair to say that these violations have a current impact on public health, safety, welfare, the environment, and wildlife, or wildlife resources? In which case, that's one of the reasons it's being brought before us. or is this just a matter of the egregiousness of the allegations and that being kind of what dictates it coming before us?
Director Murphy, AG Stafford.
Thank you, Chair. Thank you for the question, Commissioner. On the one hand, we do see ongoing environmental impacts, which are concerning. And I think that necessitates moving quickly. And also kind of the package considered together is concerning. There are a number of incidences that we have with different operators with kind of a here or there, but they're kind of sweeping issues that we're seeing, and with ongoing environmental impacts that is of concern to me. And Ms. Stafford, if you want to add to that, please do.
Sure. Thank you, Director Murphy. And I just want to caution us all, and I know that my colleague AAG Davenport would hopefully agree with me, that we don't want to get too much into the merits of the matters at hand here. But I agree with Director Murphy's conclusions in this matter. We, with respect to the question that you asked, we think I think both both suggestions you made sort of lend to staff's argument here, that we believe that not only are there continuing compliance issues, but that they are particularly egregious and ongoing.
That's fair enough, AAG Stafford and Director. I appreciate the attempts to get at what I was trying to understand. I understand the limitations with getting to the to the content of the actual allegations and the hearing matter itself. So I will leave it there. Thank you.
Thank you, Commissioner Gonzalez. Other questions from, or thoughts or considerations from commissioners? Commissioner Nanjapa?
Thank you, Mr. Chair. I also concur with some of the comments that you made, as well as Commissioner Gonzalez. I agree that either party can make a motion requesting that the matter be heard by the commission. And I do believe that this is something that should come before the commission, given the facts of the matter that have been presented to us, and especially for me in particular, the volume and nature of the allegations and the consolidation of multiple dockets. It does convey to me, especially with the responses that Director Murphy and AAG Stafford just gave, that there is some urgency, and of course in having us hear this, there is some efficiency that is gained, and we will of course be hearing from KPK directly with respect to their presentation of the facts as they believe have occurred. And I do think it's important for us as a commission to hear this, and would also echo what Chair Robbins said regarding the fact that we are now a full-time commission and can perhaps hear more of these types of cases. I would also agree that seeking the assistance of the hearing officer to handle some of the pre-hearing tasks would be very helpful, and I'm open to dates as will work for the various parties, but especially ensuring that we have the commissioners as well as our AAG Davenport available at the time. And I think last but not least, I'll just note that for perhaps a future discussion, I would like to perhaps establish some criteria of when we as a commission might hear certain types of enforcement matters that maybe meet certain circumstances. And so I'll just say, put that in as a placeholder for a future discussion.
Commissioner McGowan?
Thank you, Mr. Chair. I'll just say I agree with what's been said before my comments. I think too, knowing that there's kind of a backlog in our enforcement queue, I did read KPK's motion and that their thoughts that simpler items should come to the commission, and I actually don't necessarily agree with that. I think the enforcement issues that have come before the commission to date that have been on our kind of consent agenda, the ones that I personally have been pulling up are those that have questions for me that seem a little complicated, or I have concerns about the egregiousness or what might be happening, or and I think this is one that I might have pulled off anyway to ask more questions about. So it seems appropriate to have the commission help address the backlog with something that might take more time for staff to do versus the commission doing. I think we might be more efficient at tackling it. There seems to be some extra need for urgency that may not exist in some of the other enforcement cases that hearing officers are addressing. And so I think it should come before the commission. And I agree with Commissioner Najapa, we should probably have a conversation about what kinds of enforcement cases do belong in front of the commission at some future date. And I would also be interested at some future date looking at how we're dealing with enforcement overall. The follow-up we have as staff, what kind of enforcement issues we're seeing, and that might help us make some decisions too as to how things are getting tackled.
Commissioner Messner?
Thank you, Mr. Chair. I don't have a lot more to add. I think the other commissioners certainly shared many of the same thoughts that I have. I do want to emphasize that something that was very compelling to me was the egregious nature of the accusations and the NOAVs and the need to expedite this process. And I think that bringing it to the full commission is the most expedited process that we have. And I think the procedure to do that was done appropriately. And so I do think that this is something that I think the full commission should take up and we should move forward on.
Other thoughts from commissioners or from staff? Anything from AG Davenport at this point? Commissioner Messner.
Sorry, one other thing, Chair. While I appreciate allowing some leeway as far as scheduling this, I do think that the urgency is an important aspect of this. And so while I want to make sure that we're all going to be able to attend, I want to, from one commissioner, urge us to do this at the soonest possible date that we can get everyone together.
And that everyone includes AAG Davenport. Commissioner Gonzalez.
Yeah, I appreciate that, Commissioner Messner. I wanted to make that same point. Is, you know, for me, one of the cruxes of why I want to bring this up before the commission, you know, involves the serious allegations that have been set forth here, and the urgency associated with the allegations potentially having impacted or threatening to impact public health, safety, welfare, the environment, wildlife resources. I think that we have, as commissioners, as professional commissioners, the time, the ability, the expertise to work through this in a hearing forum. And so I also believe that, you know, given the urgency and the seriousness of the allegation, that it is important that we continue to move this forward in a timely fashion so that we can get to hearing these allegations in a hearing setting from all parties and get to the bottom of what's going on. So that's where I'm at with that, Chair.
Thank you, Commissioner Gonzalez. Since I started this, I'm going to rattle off my notes one more time, and then I'll look for a motion. The motion would include agreement by commissioners that any party can ask the commission to take an enforcement matter up at a hearing, that there's agreement with commissioners that with the hearing officer's recommended order, that we should indeed hear this case. We do not desire to hear it on June 23rd to June 30th. We do desire to hear it sometime as early as possible within the month of July. We would direct the hearing officer to ask the parties how long the hearing really needs to take, and then check with the parties as well as commissioners on available dates during the month of July, and then schedule the trial or enter an order scheduling the trial, and for the hearing officer to continue to finalize all additional pre-hearing processes. And if I missed something, folks can add to it when they do their motion. AG Davenport, you mysteriously appeared down in the left-hand corner. Did I miss something?
No, you didn't miss anything.
So without putting words in your mouth, I'm looking for a motion along those lines.
Mr. Chair,
Commissioner Nanjapa.
I move to, I'll look to AAG Davenport for wording here if I'm tripping up, but I move to accept that either party can make a motion requesting that a matter of enforcement be heard by the commission, and that we accept the order that has been provided by the hearing officer with respect to the commission hearing this particular matter, and that we determine the dates at a later date upon consultation by the hearing officer with the other parties. Is that sufficient, AAG Davenport?
Thank you, Commissioner Nanjapa. If it's acceptable to you, I'll restate slightly. I think the motion is essentially to approve staff's motion to remove the hearing to the commission from the hearing officer and to adopt the hearing officer's order, recommended order, other than the date of hearing.
Thank you, AAG Davenport. And
yeah.
I would accept those changes. And a question, if I may. Do we need to, thank you, Mr. Chair. Do we need to stipulate about the involvement of the hearing officer within this motion, or is that something that we can, with respect to the pre-hearing tasks?
AAG Davenport.
Thank you, Mr. Chair. At least in my view, the motion is clear and the commission's instruction is clear. I don't think you need to restate everything that's been said in the course of deliberations in the motion itself.
Great. I think we have an acceptable motion from Commissioner Nanjapa. Do we have a second?
I'll second the motion.
We have a motion and a second. Is there further discussion on the motion? I always forget I'm supposed to do that under Robert's Rules of Order, give folks a chance to discuss after the motion is made. But I'm not seeing further discussion. So with that, all those in agreement with the motion indicate by saying aye.
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 Any opposed? The motion carries. I believe that is the end of the agenda for the Colorado Oil and Gas Conservation Commission on June 2nd. Does anybody have anything else? Great. We look for a motion to adjourn.
So moved.
Second.
A motion and a second. All those in favor signify by saying aye. Aye.
Aye.
We are adjourned. Thanks, everybody. Thanks for being with us.